Hey everyone, Mark Trenner here from Trenner Law Firm. Now, you might be wondering why I have this big orange T on my shirt today. No, it's not for Trenner. It's actually University of Tennessee. My son just graduated the engineering department, got his computer science degree, and so you're looking at a proud parent. But I digress. Let's get on to the video. If I had $1 for every time an inventor or startup founder sat in my office, showed me their brilliant prototype, and asked me, "Hey Mark, can you help me sell this? Do you know anyone at Apple or Target or Hasbro who'd buy this from me?" Well, I might not be rich, but I'd probably have a whole lot more prototypes sitting around. Look, I love the enthusiasm, and I always give them the honest truth. As a patent attorney, my job is to build your legal shield. It's not to act as a sales broker or a marketing agency. I'm just not good at that. So if any lawyer tells you they can guarantee introductions to Walmart executives, for example, or get you into Google, you should probably walk the other way. But here's the good news. Over the past 20 years of doing this, I've had a front row seat basically watching hundreds of independent inventors and startups successfully get their products onto the store shelves of big companies, big stores, onto Amazon, and licensing deals with big companies. So today, I'm breaking lawyer protocol and sharing the exact playbook they use to get their inventions in front of the right people. The biggest mistake I see excited founders make is what I call the blast method. They get an idea, they build a prototype, and they immediately start cold emailing companies or posting about it on social media, making TikTok videos just to drum up buzz. I get the urge. You're excited. But from a legal perspective, that's terrifying to someone like me. When you blast an unprotected idea out into the wild, put it on social media or anywhere on the internet, two bad things are going to happen. First, a bigger company with deeper pockets and faster manufacturing can simply see your idea, tweak it a little bit, and beat you to the market. Second, the patent law is very strict about public disclosure. If you share your invention publicly before taking the legal steps that you need to, you can actually permanently destroy your right to ever get a patent. You lose your leverage before you even start. So how do you actually get it in front of the right people safely? Here are 3 things that successful inventors do. First, look for open innovation companies. Not every company is open to innovation, but there are some out there. There's major corporations that actually have dedicated portals on their website specifically for independent inventors. Like I said, not all companies do this, but some do want outside ideas. And the ones that do have a very specific process for submitting them. Find those portals. Second, master the what versus how rule. When you're early in the pitching process, your marketing should focus 100% on the what, who, and why. What problem does your invention solve? Who's the customer, and why is it a game changer? Keep the how, the exact mechanics, the code if it's software, the secret sauce of any invention, completely to yourself. Third, bypass the generic, info at whatever company email addresses. Instead, go to LinkedIn and look for people with titles like product manager, director of innovation, or category manager at your target companies. Those are the decision makers. Those are the ones who are actually willing to consider new products. All right, but here's the golden rule that ties this all together. Never pitch a company unless you have it locked up. When I say locked up, I mean patent pending. You don't want to walk into a pitch meeting asking some corporation to sign a 10-page non-disclosure agreement. In fact, most corporate legal teams will flat out refuse to sign an NDA before they even know what your product is. And even then, that's not what they do. So what's the alternative? Like I said, patent pending status. Get your patent application filed. You don't need an NDA. By filing a provisional patent application, you automatically get 12 months of legal protection. You're locked in as patent pending. It basically acts as a keep out sign, or hey, I've put my stake in the ground. It gives you the confidence to walk into any pitch meeting, look them in the eye and say, here's my product and it is patent pending. My law firm helps startups and solo inventors get that protection quickly, securely, and entirely on a transparent flat fee basis. So before you send that next pitch or email, let's get your shield up. And by shield, I mean patent pending. Head over to ipatentattorney.com, that's my website, and book a free 15-minute strategy session with me today. Let's protect your idea so you can go out there and sell it. See you in the next video.